However, the authorities may authorize, in line with European law, this transaction or this merger. It is up to an advisor, as I am one of the advisors, to check before the transaction whether this transaction may affect a German or European antitrust law, and to check before the transaction whether we will have an impact on this transaction. So without the approval of Germans or European antitrust authorities, the deal or the closing of such a deal will not be valid. And this will lead, of course, when you have that kind of merger agreements to kinds of consequences regarding the contracts. Either there are some withdrawal rights agreed in the contracts, or there are some compensations or damage claims that will come up if the needed approval from German or European antitrust authorities were not given. So the main point is, before an M&A transaction, we have to check German and European antitrust law. Regarding the point that we have today, the unfair competition law, it is regulated in the German Act Against Unfair Competition, the UWG, so I will call it, to simplify it, the Competition Act. And this Competition Act is intended to shield competition from distortion, misinterpretation, and unfair practices in the interest of competitors, consumers, and other operators in the market. The legislation of competition law covers inter alia advertising law, unwanted advertising, as we have in Germany very often right now due to spams, due to email, due to email advertisement and so on. It also covers cases of misleading advertising, and it leads to the point that also standard terms and conditions, as we use that very often in contracts, have to be checked if they comply with German competition law or not. If they are not valid, this would affect the German competition law, and could also lead to compensation and damage claims of such companies using invalid or illegal standard terms and conditions. But I will come to this point later on. There is a ban on unfair practices by competitors and market operators that may distort competition. The law on unfair competition contains an all-embracing general clause comprising an extensive list of unauthorized competition practice. That leads to the fact that although in Germany we do not have a case law as we have it in the Commonwealth or in the US legislation, regarding to the competition law system, by fact we have such a case law. So we have some cases judged by our courts that have been now in the last revision of German competition law, that have been introduced to the Act. I will show you then some cases that have been introduced to the new competition law, and maybe later on we may discuss some of these points. So what kind of competition practices are legal or are illegal? If a company discovers that a competitor is in breach of competition law, this company can issue a warning, demand immediate cessation of the activity, and call for recovery of the damages. The competitor then may have to make a cease and desist declaration that he will not anymore violate competition law, and that he will stop with that kind of business activity. If he will not, then he may claim also, he will be claimed for damages and for reimbursement, for example, of attorney fees. Competition law. We largely recodified this act in 2004, and due to a European directive We had also a review on this law and the recodification in 2008 in December, so it's quite nearby, where we had to include to our competition law some unlawful practices regarding email advertisement, regarding standard terms and conditions to our competition law. As long as unfair competition law is not harmonized on a European-wide level on the basis of the corresponding European directive, practitioners of the market will also have to concentrate either on German competition law and also on European competition law. The revised German Act against unfair competition is to a large extent codifying existing case law, as I mentioned it before, thus providing more transparency of the law against unfair competition for the market participants. The German Unfair Competition Act, UVG, the competition law, protects competing companies and the consumer against unfair competition. Misleading advertisement of a competitor or piracy in goods and services are example for acts of unfair competition. So the German Act against unfair competition prohibits certain trade practices which are considered to be unfair, but excluding all the areas that are already regulated by antitrust law. That means especially all this wide field of merger control. This is regulated by antitrust law. It's not a point of the competition law. The Act Against Unfair Competition has been revised with the aim of modernizing German law against unfair competition and bringing it into line with European directives. The last revision has been made, as I mentioned it, in December 2008, so it's quite new.